Hi there, I'm Will Trackman. I'm the General Counsel here at Mountain States Legal Foundation. Welcome to our webinar on the SCOTUS term 2024 to 2025. We're here today to talk about some of the most important SCOTUS cases from the last year and the cases that Mountain States Legal Foundation had a distinct role in achieving victory and making sure that these precedents set a decision on these important issues for the entire nation. We're happy to have with me here today two guests, Mike McCoy, the director of our Senator Keep and Bear Arms, and Ivan London, the head of our Natural Resources Practice Group. We're going to go about 30 to 40 minutes talking about these issues, and we hope that they're informative and let you know what was decided last year and set us up for the future. With that, Mike, I want to just dive right into it. Mountain States Legal Foundation had a direct representation case this year called Vanderstock. Can you give us the details on what happened in this case and what the court ruled? I know we were hoping for a better outcome, but at least we had a Supreme Court case, and I want you to talk about the result and how it may affect the future.
Sure. So Vanderstock case involved a Biden-era ATF rule that was, or change to the rule that was imposed by Biden's ATF in 2022. And what that did is it changed what had been at that point a 50-year precedent on what qualifies as a firearm for purposes of regulation. And it expanded it to include not just things that are already capable of ejecting a projectile, but things that might turn into that eventually. So this obviously impacted things like frames and receivers that were not quite complete, as well as just weapons parts kits in general. What's the big deal with that? Well, the big deal is that there is a very robust and long-standing history, tradition in this country of people manufacturing their own firearms. And in recent years, people have used gun kits to help them with that process. The ATF was not happy with this, and the anti-gun folks were not happy about this either, and they were seeking ways to regulate it. And one of the ways that they did that is by changing the rule and changing, in essence, the definition of what qualifies as a firearm for purposes of regulation, or the ability of the ATF to regulate it, to include things like homemade firearms. So we filed suit on behalf of our client, Jennifer Vanderstock, who is a former law enforcement officer who had this hobby of manufacturing firearms in her back porch, and took the case all the way up to the Supreme Court. We had victory at the district court level, and we had victory at the Fifth Circuit, and we expected similar victory and a similar ruling out of the Supreme Court. Unfortunately, the court didn't give us the answer that we wanted to give us, but it wasn't all negative. The court was very limited in its ruling, and it talked about weapons parts kits or frames or receivers that can be readily converted into what they're intended to be. And they specifically mentioned, and really only mentioned, one particular type of weapons parts kit, and that was the Polymer 80, which required the removal of a couple of different things and the assembly of a couple of different things, something that would take 15 to 20 minutes to accomplish. What the court left wide open, though, was what about the gun kits that require much more time, effort, and knowledge, or machinery in order to convert that piece of equipment or those kits into an actual functioning firearm. And so because of that, the Vanderstock case really creates more questions than it answers, and really didn't solve a whole lot. It was technically not the ruling that we wanted, but it leaves the door open, actually, for us making challenges in the future if the ATF decides to go after Americans who are simply trying to manufacture their own firearms.
There was a dissent in the case, yes, from Justice Thomas?
A very strong dissent. In fact, I think the dissent is longer than the actual opinion itself. And Justice Thomas said he didn't buy any of the court's reasoning on this. He said that his main point is that Congress has had the opportunity multiple times since 1968 to change the definition of a firearm, and they've repeatedly refused to do so. And to expand this definition so greatly as the ATF did in 2022 is exceeding the authority that Congress gave the ATF back in 1968.
And in this case, it was the ATF reinterpreting its own authority to say, we do have more power than we thought we did to regulate these gun kits that are pejoratively called ghost gun kits. But the case isn't quite over yet, because this was just a ruling on the administrative procedures part of the case. The case currently lives on, is that right?
It does. The There were many claims filed initially when the case was first filed in the district court in Texas, and several of those claims still live. And in fact, there's a Second Amendment claim, there's a due process claim there's even a First Amendment claim, all of which are still alive at the district court level. What happens with those claims is yet to be determined. Some of the plaintiffs have decided to back off, others are leaning into it. And because of that, it's yet to be determined what's going to happen with this case. But I think what's also interesting is we have a new administration, we have a new ATF director, and we have an executive order that was issued by the president in February that specifically directed the Department of Justice to go back and look at these Biden-era rules to see if they are violative of the Second Amendment. And because of that, the DOJ in the Vanderstock case, once Trump came into office, asked for a stay of the case at the district court level so that they could conduct this review. And so there's a potential that we have a victory on the back end through the new ATF director deciding to back off on this rule.
Yeah, I like the attitude, never say die, right, at Mountain States Legal. So the Trump administration, I don't think ever would have gotten to that point if we hadn't brought this case all the way through the district court, the appellate court, the Supreme Court, gotten a strong dissent from Justice Thomas, and now continue to focus on this case on remand. So there is a silver lining here, and the case lives on at the lower courts. We'll have another update, I'm sure, in the future.
Yeah.
Let me switch gears, Ivan. Let's talk about a case where we were amicus.
Sure.
That is a friend of the court, where we filed a brief in support of the court either hearing the case or deciding the case a specific way. Let's start with the 7 counties case. Talk a little bit about that, and then what the result of the case was, and maybe the theories that we presented in our brief.
Happy to do that. And to start from the start, actually, it's 2 briefs, right? It's Supreme Court. I'm sure many of our listeners will know this, and you guys know this, but there are 2 different stages. One where you ask the court, will you please review this problem? And then another where we deal with the actual merits of the case once the Supreme Court has said yes. And that's very rare. It's very rare. So this case came out of Utah, 7 County. Where in the Uinta Basin of Utah, there's a prolific oil and gas basin. And there are communities there, and both of those things have one thing in common, which is that they have no way to get out. It's exaggeration, but they wanted to develop a rail line to help, get things in and out of this remote area of Utah. So a proposal was made to the federal government, the STB, Transportation Board, it's hard word for me to say, obviously. About, can we build this railroad? And Congress, which represents all the states in the country, has already put into law that we presume that we want to build these railroads to connect people, connect goods, to bring our community together. It's right there in the law. And yet, there are other laws that are also important, like NEPA, the National Environmental Policy Act, that require procedures to, put a pause and check on the environmental effects, potentially, of what you're doing. And that has become, NEPA has become a tool for people who object to a plan or a project to step in the way and try to stop the project, which is okay, that's fine. But it's gotten kind of taken out of hand in the last several decades. So these groups who wanted to promote the railway filed an application. The STB approved it. And had done hundreds and hundreds, maybe thousands of pages of environmental review in the process to show their work. It's the important part, right? Show your work. You don't have to make an environmental based decision, but you have to show that you considered it and then explain why you're making the choice you're making. They did that. All's good. The anti groups who objected to this project filed a lawsuit, and they really wanted to make sure they stopped it. They took it to the court, and the federal court that reviewed it said, "Hey, look, you guys did all these things you're supposed to do, but you didn't explain in enough pages. What about if you're going to put this railroad in that might facilitate some oil and gas development in this part of Utah? What if there's more oil and gas development, for the drillers in Utah? What if there's more refineries or refining, downstream, and maybe it's the Gulf of Mexico, maybe it's around the world." Now the agency acknowledged all those things and said, "Well, we have to cut a line somewhere.
Yeah,
we can't, that's not, we're in the business, our job, our statutory demand is to figure out whether to build a railroad or not. It's not about regulating international, not just nationwide, but international greenhouse gases. So the agency looked at it and said, we understand these are issues, but they're not within our wheelhouse, right? They're not, and they're not really within our mandate. I don't think we're allowed to actually rule on this because we as an agency have to stay within the law, which is an important point. The federal court that reviewed it said, no, you have to review these things. And that's when it went to the Supreme Court. And this question of, well, what is the limit for a federal regulator on deciding, when to draw the line on his or her authority to, or not even authority, but just like making decisions. I think here at Mountain States, we don't always advocate for more governance and more administrative state. We do want good governance though. We want regulators to have a chance to make good choices without being second guessed in extreme by judges.
We don't want activist groups saying, sure, we're going to stop an energy policy because you didn't think enough.
Totally. We also, whatever the position, we don't want judges injecting their policy into a regulatory decision, right?
And here it was a county in Colorado, right? It was a Utah project.
It's a Utah project. The rail line that would be connected to went through Colorado. It started really, I think everyone can understand this. This county in Colorado being concerned about having more railroads, more trains going through the county with some oil in them. But that was co-opted very quickly, the case, by groups that were focused more on international climate change alleged issues. So it went far beyond this county to a big, broader thing. I think the SDP, the agency that involved, looked at those things very clearly, very closely, and very thoroughly, and put that all on paper, put it all in writing. So we were approached, as the federal court said, no, you should do more. We were approached by our clients and friends, the American Forest Resource Council, and then eventually Western Energy Alliance also.
Yeah.
Right. So representing different industries to say like, this whole NEPA process has gotten out of control. The Supreme Court should take up a case where it kind of tries to put some restraints on or help refine where the lanes are. For judges, for regulators, but also really for the judges, right? Your job is to make sure that what the regulator did was reasonable. That's it. You might disagree, you might agree, it was unreasonable. And at the end of the day, the Supreme Court, I think unanimously, right, decided, yeah, the agency was reasonable here, right? They did all the things they're supposed to do. Now, the fact that there are some concerns about what might happen locally in the environment, or even internationally, they didn't like get that too much. Sure, they can consider that. They did. The agency did do that. And that's the point. They did. They considered it. So let's not let anyone who has a problem with that just step in the way of development.
Because you could easily weaponize a procedural statute and say, you didn't think about this, you didn't analyze that. There's a secondary or tertiary or more and more down the lane and say, you have to think about those things or the whole project dies.
That's right.
And now Supreme Court thankfully put some limits on this, consistent with what we argued in our.
I think that's right. Well, two briefs, right? So we did argue both the Supreme Court should take the case, and then also the Supreme Court should review it once the Supreme Court took the case. Like, let's help you understand, right, what is at stake here and why the side we're on is right. But you're right. There has to be some limits on the scope of review for any given regulator. In his or her capacity, like, well, we can't, stop projects because of some tangential, far off, attenuated issue. And maybe it's an important issue, but it's not related to this project really at all. And so that's what the Supreme Court came out and ruled, right? This is about whether or not to approve this rail line. The agency did a good job this time. Sometimes we're on the side of the regulators, right? If they do a good job, we're on the side of that. And no offense. If they're doing a job, we're on the side of that. And, the project should move forward. That's good governance, and we do support that.
Well, good result. I'm glad to have it. Mike, I want to switch back to the Second Amendment world and talk about a different case where Mountain States filed an amicus brief about the government of Mexico, which Estados Unidos means United States normally, but this is United States of Mexico, Estados Unidos, and they sued Smith and Wesson over tort liability, like a civil claim for liability for selling guns to cartels in Mexico. Tell us about that case, our brief, and the result.
Sure. Yeah. So the anti-gun folks are relentless in trying to find new and creative ways to undermine our Second Amendment rights. And one of the ways they did that most recently is by encouraging the government of Mexico to sue Smith and Wesson, as well as 6 other gun manufacturers in the United States, blaming them for the cartel violence, the drug cartel violence in Mexico. Bear with me here on that logic. The logic is that the U.S. gun manufacturers make firearms. They place those firearms into the marketplace. Some of those firearms in the marketplace are sold by dealers to Mexican cartel members. Those firearms are then used in Mexican cartel violence, and therefore the gun manufacturers are responsible for that. It's a stretch, to say the least. And quite frankly, the Supreme Court concluded similarly that it was a ridiculous stretch as well. So Justice Kagan, in fact, is the one who wrote the majority opinion in that case. She concluded that PLCAA, the PLCAA, which is the Protection of Lawful Commerce and Arms Act, which was passed by Congress specifically to stop this type of lawsuits, these types of lawsuits against the gun manufacturers, applied in this situation. Because the only exception to the PLCAA is if you can establish that the gun manufacturer knowingly aided and abetted in the commission of a crime. So in order for Mexico to have been successful in this case, they would have had to establish that the gun manufacturers in the United States knew and assisted the drug cartel in Mexico with committing violence.
And it had to get to the Supreme Court before it was knocked out.
The district court knocked it down right away, but the First Circuit, which is the First Circuit, actually said that Mexico's claim could go forward. And so this was then quickly dealt with by the Supreme Court. What's dangerous about these types of cases, though, is, again, as I said, this is the anti-gun folks trying to find new and creative ways to attack our Second Amendment rights. How does suing the gun manufacturers do that? Well, because if lawsuits like this were to go forward, it would bankrupt the American gun manufacturers, and it would destroy that industry. And if you destroy that industry, our ability as Americans to easily acquire firearms to actually exercise our Second Amendment protected rights would be undermined. So that's what they're after. And they tried to do that in this case, and they failed, thankfully. And the Supreme Court reached certainly the correct decision.
Yeah, it's not Smith and Wesson's fault that Mexico can't control its cartels.
No.
Right? But I think the Supreme Court was persuaded by that logic. So I'm going to talk about an equal protection case that the Supreme Court decided. Another unanimous opinion. The theme here is that we've had a couple of unanimous victories from Mountain State's amicus briefs. This one is called Ames. It's a case out of the Sixth Circuit, and it's an employment law case, so not natural resources, not the Second Amendment. And it involves a woman who was suing for employment discrimination. She was a heterosexual employee who was denied a promotion and then demoted twice in favor of homosexual employees. And she said that is sex discrimination because you are promoting gay employees over straight employees. The Sixth Circuit said, because what you're doing is suing over an issue that involves a majority group, that is, heterosexuals are a majority group, you have to plead some extra things in order to survive your motion for summary judgment. Otherwise, your case can't go forward because it's weird that an employer would discriminate against the majority or heterosexuals. So this doctrine has been applied in other contexts when men sue for employment discrimination, when Caucasians sue for employment discrimination. And in fact, when Mountain States had a case a couple of years ago involving a prison guard named Josh Young, the Attorney General of Colorado said, well, you're white, so you have to plead extra circumstances in order to keep your case alive. Otherwise, why would an employer discriminate against white people? They're the majority of Coloradans. The Sixth Circuit decided to affirm the dismissal of Ms. Ames' claim. She went to the Supreme Court, and in a unanimous 9-0 opinion written by Justice Ketanji Brown Jackson, a Biden appointee, the court rejected the background circumstances doctrine, this was called, saying Caucasian plaintiffs, heterosexual plaintiffs, male plaintiffs don't need to do anything extra in order to bring their Title VII, that is the employment discrimination claims, to court. The result also had a concurrence, a terrific concurrence from Justice Thomas, who wrote also in Mike's Vanderstock case, saying that it's no wonder that these cases are proliferating because employers are engaged in more and more DEI efforts. So that's really the reason why majoritarian plaintiffs face discrimination more and more in today's age. In our amicus brief, we urge the court to go even further and make broad sweeping rulings about courts using race as a factor in any decision whatsoever. Unfortunately, the decision was a little bit muted because Justice Jackson wrote it and it was unanimous. And of course, you have to say limited amount of things in order to get unanimity on the Supreme Court. But it's a good result and certainly one that we can take forward with us to future cases involving DEI and race discrimination. All right, that's the mineral protection case. Ivan, I want to turn back to you on the Diamond alternative energy case. This one is about standing, but it has important ramifications in our work, I'm sure.
Well, it absolutely does. Well, constitutional standing is that word, but definitely in the environmental energy area is an important case. This is a case that came up out of the ongoing challenges that the several are facing with the federal EPA laying the state of California set nationwide policy for car manufacturing and what are the downstream, so to speak, effects of that. And that's how the case has been postured, so that the Clean Air Act has a provision that lets Los Angeles deal with smog problems that is separate from the federal system we generally have. And that's how it's always been treated. But recently, recently, legal time could be decades, but recently, it's been treated as a way for Southern California regulators and then all of California regulators to say, well, we have a lot of market share, a lot of market power with these car manufacturers. So what if we decide what the standards are? And everyone else in the country has to follow suit, right? Because if a car manufacturer can't sell cars here in California, well, they're going to change their policies. California.
Yeah.
I see you guys. I saw you nodding hard. You live there. It is exactly.
I apologize.
So yeah, hard lead-in. But the Clean Air Act does say that Southern California can have a little exception, a waiver, to deal with what at the time, decades ago, was a Southern California smog problem, and that's been transformed. The question is one question, the legal question there is how far does that go? Can California set nationwide policy? One of the weird things, though, is that statute lets the California statements sundown, basically go out of place every few years, so that you can never actually get a thing to a head with the courts. And the main places that's challenged the DC Circuit appellate court, and they have that court has found ways to say that, well, this is going to end. Not our problem, not a problem at all.
Because the lifespan of a lawsuit
that's right.
is longer
Yes.
than the amount of years.
Sorry, I know, as we all know, but I appreciate. Thank you. Yeah, the lifespan of a lawsuit, the wheel just could turn slowly sometimes. But still, someone has to be able to challenge this rule. It's a law, but then the EPA actually grants the waiver. So it's an agency decision to say, we check in every couple of years. Either you can or you can't do this, California. That's called the EV waiver, basically the California waiver. And in the most recent years, the federal EPA has given California permission. We will waive our federal EPA jurisdiction over you and let you set your own policy, even though it kind of sets national policy. So that was challenged in court, right? Can the federal EPA do that under the law? And like I said, the courts, especially the DC Circuit Court, have repeatedly found ways to not answer that question by looking directly at statute. But by saying, hey, look, it's a sundown, or these things, it's never really a problem. Even if we get to it in 6 years, we can't help you. That most recently came up, though, with a decision that when the fuel refiners, so not the car makers, but refiners who provided liquid fuels for cars, challenged the most recent waiver at the time. The DC Circuit said, well, this only really targets the automakers. You guys have no business here. Well, they said, well, yeah, actually we do. It's our business, right? This is our business. And so they appealed that to the U.S. Supreme Court. And the U.S. Supreme Court took up this environmental issue, but on this question of, can anyone besides the car manufacturers bring a case about, what seems to be very obviously a regulation that's so wide threatening like that as a term.
Because up until now, the courts have said, we don't have jurisdiction.
That's right.
To get to the underlying question.
And we hope we never
whether-
do.
Yeah, whether this was a lawful thing or an unlawful thing, because you aren't injured.
That's right.
If you, or
Or if you were, now your injury's over.
we could
Yeah,
never
exactly.
prove that redress.
But the
Your
California mandates have only ratcheted up to be, for example, in the most recent version, which is not a report yet, an EV mandate, no fuel cars by 2035.
Yeah,
Right.
yeah.
So these things have ratcheted up, and so the stakes have only gotten higher. They've always been high. They've only gotten higher. And it just seemed kind of counterintuitive, I think, for me, not as a layman, as a lawyer, but also as a layman, right? If something like that will affect your business negatively, that a regulator is doing, well, you should have a right to go to court at least. Now, you might win or lose,
Right.
whatever it is, but you have a right to go to court. The DC Circuit said, no, you don't. Because this is really about the car manufacturers, not even about the refiners who are providing liquid fuels. And it seems like very obviously would target them also.
Yeah.
I mean, the whole theme behind it is that the state of California wanted to get rid of liquid fuel.
Right.
Period. Full stop. What we did as an amicus, though, both at the certiorari stage, again, we touched on the two stages, right? Helping the Supreme Court realize this is a big problem. And then also that when the Supreme Court said that it was, and they would review it, helping them understand it, we presented a few great groups covering a diverse series of people. The American Royalty Council of Oil and Gas Royalty Owners, Texas Oil and Gas, Texas Royalty Council, Texas Oil and Gas Royalty Owners. So they're just landowners, right?
Yeah.
But they get income from leasing their property they own. They get an expected income from that. Well, wouldn't this rule work then?
Right.
If there's no more reason to have liquid fuels?
And this was yet another win. That
Oh, we're getting there. Yeah,
reversed.
getting there.
Yeah.
Yeah.
And so what did the Supreme Court say in reversing?
Oh, well, it said that obviously, well, that's the short part. That's what I was going to say. Our client. The other client, though, is the National Association of Wholesalers and Distributors,
Yeah.
who represent the supply chain. All the vehicles that help you get what you want in the world are represented by our other client, NAW. But the Supreme Court, I mean, this is one of those where it seemed like a slam dunk and pretty obvious they should take this case and they should rule this way, and they did, right? Yeah, it's not just the car manufacturers that are hurt by this rule. There are others who are reasonably within the zone of who this rule hurts, and the courts can't slam their doors. That doesn't mean any given claim is going to win or lose, right? They have to have access to our courts to challenge the rule. Now, you could be, I'm sure, so attenuated that you're so far away that you don't really have an argument there. But it seems very clear that it's somewhere in the chain that's so close to the actual thing being regulated.
Right.
You have to be able to challenge it. But the Supreme Court ruled that way.
So you say obviously, but of course it took, just like Mike's case and the SCOTUS case, it took to the Supreme Court before they actually got to this ruling. The lower courts had said you can't bring your suit here. You don't have jurisdiction.
You don't have a theory on this, though, right? I do think that the Supreme Court, especially this term, especially combined with last term, is taking a priority in trying to help the lower court judges understand their job, especially in the administrative law context, the cases that I work in, right?
Yeah.
7 County, the Diamond Term Energy case, then you go back to Loper Bright, helping the lower federal courts understand, not in a negative or positive, but understand what is your role, what is your lane, right? Can we put some parameters out there so that you know what your job is? And then the litigants, if we have a dispute, we know what the playing field is.
Yeah.
I think that's a really important thing, and we've fought for that for sure, right? A fair playing field.
Yeah, it's interesting. In Vanderstock, on all of that, so the first case we talked about, the oral argument that Mike and I were there for, Justice Jackson said, wouldn't this case be so easy if we still had Chevron deference to executive branch agencies? We could just say, yeah, ATF, you win.
And that's the point, right?
Because you think you have the authority, you do have the authority. And I think we've seen in Loper Bright, which reversed that Chevron deference. And then in a couple of other cases, the court saying you cannot abdicate your role. You must do the things that are within your lane in order to, dispense justice.
Now, they might be hard. They might be hard to work, but I mean, it's part of the job.
Yeah. Because I mean, like I said, with the SCOTUS News case, in your case, sometimes it takes the Supreme Court to point out what's obvious. That was also true in Ames, where you think, why would you treat white plaintiffs different than other plaintiffs? Seems especially in the context of discrimination, you wouldn't discriminate. And of course, that's how you
Counterintuitive.
unanimous rulings. So I did want to talk a little bit more about one case that we filed that we tried to get certiorari on, called Advance Colorado. That was a case in the First Amendment where we asked the court to get involved in whether our client was being forced to engage in compelled speech when they were circulating ballot petitions that had language on them that implied that the tax cut that they were trying to propose would hurt healthcare and other services in Colorado. We did get the court to order a response. The Attorney General had to file a brief trying to argue its way out of certiorari. And unfortunately, the court did decline to grant certiorari. And it does seem like in some cases, maybe the free speech context, maybe the equal protection context, the court is kind of metering how many cases it takes on a given subject every year or so. Mike, do you get the same sense in the Second Amendment sphere? They had Bruin, they had Rahimi. These are major Second Amendment cases. And here, this year, we did have Vanderstock and Estados Unidos that are sort of Second Amendment cases, but really they're not. They didn't take a major Second Amendment case this term.
No, and they passed on another case we wrote an amicus on, which was Wilson v. Hawaii, which is the Aloha Spirit case, which I don't know if we have time to talk about that, but it seems like this year they were trying to back off a little bit, and yet there were some indications, particularly in the Snope case, from Justice Kavanaugh, that the court will be leaning back into the Second Amendment field in the next term or two to deal with many other issues that they see bubbling up through the circuits.
Yeah, just in one other case that we asked the Supreme Court to hear called Boston Parent Coalition, there's this magnet school program in Boston where the school district had said, we won't directly discriminate based on race, on which students come into the school, but we will use geography as a proxy for race. And so the school essentially was engaged in race discrimination. And there were two justices who said we ought to take that case. But the court just decided the Harvard affirmative action case 2 years ago. So my perception, and of course it's always tea leaf reading and speculation, is that the court is letting issues percolate for a while. So they'll take a big case, they'll issue a ruling, and then it'll take a few more years before they go back to that same subject. And I'm getting that sense from some of the results in the 2024-2025 term. But that just means that next term we might get another one of these
More opportunities.
Watershed cases. Exactly.
More opportunities to file amicus briefs.
Bingo. Okay, well, excellent. So I am so glad that we have a chance to talk about the series of wins. I mean, we talked about Vanderstock and how there was a silver lining there. We talked about the wins in Estados Unidos and Ames and 7 counties.
A lot of happy clients.
Yeah, a lot of happy clients, a lot of major precedents for the future that we can be happy about. So for folks watching out there, take a lot of comfort from the fact that the Supreme Court had overall a positive term, that we got some good results in many cases that were unanimous, where textualism and originalism and limited government won out and won the day. And we aren't stopping. So in the 25-26 term, we will be there with more cases, hoping to get more precedents and build on those going into the future. So that we can talk about the victories that we obtain next year at this time. We have a very favorable court for textualism and originalism, and we think that now the time is right to win a lot of victories and solidify those precedents for generations to come. So with that, I want to close. I want to thank everyone for your support and for watching this SCOTUS briefing, and we will be in touch with more updates as they occur. Thank you, gentlemen.
Thank you.
Well, thank you.